Welcome back to another episode of the Divorce and Separation Coach podcast. This week, we're talking about child arrangements, and in particular, how formal do they need to be? Now, I see people with a whole range of expectations around this topic. Those who say, we're just going to improvise and we don't want anything on paper. And then the other extreme of people who want every last dot on every last I and every T crossed because they're really cautious about having agreements that aren't formalized. So to talk about all the different options, how they work, the pros and cons of each of them, I've invited Rachel Donald. Rachel is a partner, a mediator, and a collaborative lawyer at Russell Cooke in London. And she's got over 15 years experience supporting both national and international clients on all aspects of family law, including divorce and separation, of course, but also the resolution of complex financial matters, child arrangements, and disputes concerning child maintenance. Thank you, Rachel, for joining us. It's great to have you here.
Hi, Chloe. Thank you for that introduction. Great to be here.
So let's start maybe with the basics. I think a lot of people will have heard of a child arrangement order. Could you explain to us what it is and in what case people would require one?
Of course. Well, a child arrangements order, that is a formal court order that defines and sets out where a child should be living or how much time they should spend with each of their parents. And it can deal with lots of other issues as well, but primarily the issues that most people ask the court to deal with are those issues. So Who should they live with and how often should they be spending time with the other parent? More and more now, we're seeing courts make shared lives with orders. So quite often you can have a child arrangements order that says there's a shared care arrangement and define specifically when they are to live with each parent. So in very basic terms, that's what a child arrangements order is. But I think, as we'll probably come on to, there are pros and cons of having a specific order in place about the arrangements for your children, and you don't necessarily need one. So I would say, that's something that's important to think about before you apply for one.
So what would be the alternative then for those who think maybe that's a bit too formal for them?
So there are lots of alternatives. I mean, lots of couples who separate are happy to have a very informal agreement. Maybe they have just set out what their arrangements are between each other, written down a plan. It's always good to have a routine so the children know where they're going. But there is a middle ground and something which is suggested for parents so they have a record and a good understanding of what they've agreed, and that can be done in a parenting plan. And there are lots of really good resources about the sorts of things you can put into parenting plans from some of the national organisations such as Resolution, who's the organisation of solicitors who are committed to resolving matters amicably, but also CAFCAS, who people may come across who step in where there are child arrangements being dealt with through the courts. They have a website where there's a draft parenting plan on there as well. Mm-hmm. So a parenting plan, you can also set out what you've agreed in that document, but the difference between that and a child arrangements order is that it can't be enforced by the court. It's not binding. If somebody didn't comply with one aspect of the agreement, you couldn't, for example, ask the police to help with enforcement, and in the same way, you couldn't ask the court to enforce the order without having that child arrangements order first in place.
Yeah. And so the parenting plan is something that doesn't go at all through the court system, right? It's entirely for the purpose of the parents to have basically a document that says how everything's going to work out.
That's right. It's for the parents. It's aimed to assist the parents to sit down together, look at, right, what's going to work for us as parents and record what they've agreed. Yeah. And there are circumstances where a court may look at a parenting plan, but it wouldn't be for enforcement. It might be, for example, that the terms of a parenting plan are not working very well, or they have broken down. I've come across lots of couples who maybe actually one parent isn't quite doing what they'd agreed to do in the parenting plan, and they want to try and get an order in place to enforce it. One thing that's really worth thinking about is actually it's quite difficult to force a parent to do what they've said they'll do in an order anyway. So it's whether going to court will help that. But it can help be a useful record of what's been in place up until that point. So an example might be where one parent wants to move from a non-shared care arrangement into a shared care arrangement, but maybe they're not quite adhering to the arrangements in the parenting plan. That would be evidence for that parent to go to court and say, look, we had this parenting plan in place and it wasn't actually working as it was. Is it the right thing to do to move towards an order in the terms that the other person's seeking? So they can be used and relied upon, but not enforced by the courts.
And that's actually, you're touching upon something that's quite important for people to understand, is that both a child arrangement order and a parenting plan can be done any time. So you could be divorced 10 years and then seek, an order, for example, or you could not be divorced yet and be separated and put those kind of arrangements in place, right?
Absolutely. So, a child arrangements order can be entered into at any time, but one thing that's really important to bear in mind is that the court will only make a child arrangements order if there's a need to make an order. Yeah. So even if you don't have a child arrangements order in place at all, and you never have one in place, that's fine, because you only get one if the children need it, really, and that's based on you potentially being unable to agree things between yourselves. Another aspect of it as well is thinking about timing. I know lots of my clients, when they get divorced, for example, ask if they need to put the child arrangements in the financial order, or they often say, wait a minute, don't you need to know what we've agreed regarding the children? And it's always worth, obviously, having a record of what's been agreed, because that can feed into what the financial outcome is. But in terms of having that linked to your financial order, they can be done completely and entirely separately. All child arrangements proceedings are always driven by what's in the best interests of the children, and is an order needed? And if the answer is we don't need an order, then you won't need to go to court.
So what kind of things would the court look at to decide whether an order is needed or not?
So, one matter, lots of parents will lodge an order by consent. So, say, for example, there's been some difficulties in the past, and maybe there's been an issue with children being returned at the end of a weekend, or maybe parents have been acting unilaterally when perhaps they shouldn't have been, and that parenting plan has broken down as a result, or an agreement has broken down as a result of that, and perhaps you've reached an agreement with the help of solicitors, or you've reached an agreement with the help of a mediator. In those circumstances, as long as you've explained, look, we've tried to do this, and actually it is now important that this order is made, the likelihood is that the order will be approved by the court.
Okay. And so what are the other pros and cons, I guess, for those who are debating, do I need a formal order, or can I just get away with having just a parenting plan? What would your advice be with regards to what to consider?
Sure. So a formal order, the pros are obviously you have certainty, and you have it recorded, and you have an enforceable order. Yeah. So if things do go wrong and you have real problems with compliance, then ultimately you can ask the court to assist and enforce those terms. The cons, however, are that you have a document that's set in time and that's fixed in stone. And as we know with children, the arrangements can change regularly. So you are then sort of limited in terms of flexibility, because what you don't want to be doing really is going back and having the expense and time of referring matters back to court, getting things varied. Even, going back to solicitors and having to vary orders, it can mean that they very, very quickly become not in the obsolete moment. Exactly. So that's a downside. Another downside is that, whenever you go to court about any issue, there's obviously an element of time and cost involved in doing so.
Yeah.
So filing a consent order, you may find that a judge looks at the order and is perfectly content with it and seals it, but it may be that actually the judge who picks up that order has some queries and asks you both to come in and talk them through it. I should also say as well that any order would need to be made with a safeguarding letter from CAFCAS. So by sending your application into court, even with an agreed order, you'll have a referral made to CAFCAS, who will ring you up and do safeguarding checks. And that adds a layer of uncertainty to matters, because it may be that you or your other partner inadvertently starts talking about something that was quite historic that you worked through and resolved, but all of a sudden that does trigger some further thought and might lead to an order not quite being as straightforward as you thought it was going to be. Yeah. So there's uncertainty aspects there as well. The pros of having something like a parenting plan in place is that you can do this with a consent order, but you don't need to go back to court in doing it. But you can build in reviews and you can look ahead a little bit more. You can also add in a lot more additional issues that wouldn't necessarily be dealt with in a child arrangements order. So in a child arrangements order, the court sort of they do have a wide range of powers, but it might be on a more basic level than what you really ideally need to make things work together as parents. So in a parenting plan, you can really drill in and make sure it's bespoke to what you each want. So deal with specifics of handover. If you need to, you could deal with financial aspects, or who's going to arrange certain clubs, who's going to do what. You can go into a lot more detail that wouldn't necessarily be relevant or needed or approved by a judge if it were dealt with in an order. So that's another aspect to a parenting plan that can be very, very helpful. And I know...
Sorry, Rachel, can I just jump in there? Would it be possible for people to have a child arrangements order and a parenting plan for the details? Do people sometimes combine the two?
Yes, you could do that, but you'd need to obviously realise that the aspects of the parenting plan wouldn't necessarily be enforceable in the way that the child arrangements order is. I mean, there's other matters where you might be in proceedings already. So I've come across lots of circumstances where actually somebody's applied for an order. But in reality, when they've thought about it, actually what they want is just a conversation and to get together and actually reach an agreement. Yeah. So in those circumstances, you could end the proceedings by saying, we're not going to have an order. We have no order, but we're going to attach to the court file a copy of our agreed parenting plan. Mm-hmm. And that can be something that's really helpful as well, because then it gives both people peace of mind that they've had their order actually sitting on the court file and reflected in the proceedings should they ever need to return to court and have matters dealt with. So that can be another good way of resolving court proceedings if you find yourself stuck in the middle of it.
That's a good point. And so what would you say to those who are scared of the lack of flexibility, or the idea of putting things on paper when, of course, children are going to grow and needs are going to change can be scary to some people? What would be the argument to still formalize things in that kind of context?
I think you need to really think about the purpose of what you want the agreement to do, because if there are safeguarding issues, or if there is any risk of a child, for example, not being returned, or any sort of international issues where there might be concerns about a child being taken abroad, then you should really take some advice and think, do I need the protection of an order in these circumstances? Because it's those sort of more complex cases where actually having an order is really, really important. And, I would say as well, before you formalise any agreement, if you do have any safeguarding concerns, any welfare concerns, or if, for example, children's services have been involved or the police have been involved, it is worth getting advice before you sign up to anything, because you don't know what you're sort of acquiescing to. Because if you're agreeing to an order or a parenting plan in circumstances where actually that might not be what you really want, or it might not be what you think is right for the kids and the children, then it's definitely worth getting some advice first before you agree to something that you might not think is absolutely right. Because you agreeing to, for example, overnights might be you acknowledging that actually there isn't an issue, there isn't a safeguarding issue, when your instinct might say there is. So it's really important to think about that before you formalise matters.
Yeah. And the fact that you're formalizing through a child arrangement order or even through a parenting plan, your arrangements, does that prevent the co-parents from deviating from those arrangements if they both agree?
If you both agree, you can deviate if you think it's in the children's best interests. Quite often, in a child arrangements order, there will be an additional clause which nearly all lawyers will add in that says, you can change the agreements provided you both agree to it, or you can agree to additional time, so as is agreed between the parents, so that you don't necessarily have to keep returning to court. So there is the flexibility for parents, but quite often, the reason that a child arrangements order is necessary in the first place is because there have been some ongoing challenges. So, sometimes I say in that situation, you can't always guarantee that it's going to be open to discussion and it's going to be open to a reasonable discussion. So if you do have an order, you need to make sure it's right and one that's going to suit you on a long-term basis as well.
Yeah, that's the part that's actually quite challenging for people, is making sure that those arrangements are sustainable. Because as you were saying earlier, people their kids grow up, circumstances change, and they don't want to spend their time going back to court. So it's a difficult balance, I guess, for people to achieve. So for a lot of people, actually, having a parenting plan seems less burdensome than having a child arrangement order, because they feel there's more flexibility in that kind of situation, and they can adapt as things evolve. Is that your experience, or do you find that child arrangement orders also offer that kind of flexibility and allow people to evolve their arrangements as their children grow?
Parenting plan will definitely allow you to do it and build it in a more flexible way, because you could, for example, include various points of review within a parenting plan, where you might say, this is what we've got at the moment, but let's have a look at it again in September, and we can consider whether matters are still working for us as a family. You can, of course, do that in a consent order as well, but the terms of the order will stay in place until you agree something else. So I think it's the reverting back to court that can be the onerous and cumbersome aspect of child arrangements orders.
So in cases where the co-parents can agree on the terms, actually, there's not much harm in starting with a parenting plan and then potentially turning it into an order later on if they find that it's not as easy to enforce or to apply as they thought.
And I think that's always going to be a good starting point. The one thing just to mention that I think is it can feel quite hard to get your head around in the first instance, but it's really important to keep in mind that you really don't need an order in place if you are in agreement with what should happen for the children, because without an order, parents, provided you're on the birth certificate, you've been married at the time, you're going to automatically have acquired parental responsibility, and it's that gives you the legal responsibilities towards your children. So it's that will enable you to make a choice on where they go to school, whether they're going to have medical treatment, apply for benefits, those sorts of things. And the order is not necessarily going to give one parent greater rights than the other in that respect. In fact, it's not going to do that at all. Your parental responsibility rights will stay the same. It's just where they're going to live might change. Yeah. And just one thing that I always like to say is it's really important now that we all move away from the idea and concept of custody, because that's not a term that we would ever use in the English family courts, because we've moved to use shared lives with orders, spend time with orders. And the idea for that is that there isn't sort of a presumption that one parent is the primary carer and should therefore have more say than the other. The idea is that it's the parental responsibility that's emphasised, that parents, they're both going to have a quality and should be having a quality relationship with the children, regardless of how much time they're spending with the other. So that can sometimes feel quite nerve-wracking, not having an order for the parent who's maybe spending less time with the children. So in terms of advantages and disadvantages, that can be an advantage sometimes to not having an order, because you're not defining, you are just having something which says, actually, here's our parenting plan, we're both parents, we share parental responsibility, but these are the arrangements for them.
Yeah. And I find actually I've had a few clients who've struggled with that concept, that even if their ex barely ever sees the children, they still have parental responsibility and rights in that sense. That's not always easy for people to come to terms with when they're dealing with the day-to-day and all of the, the routine and workload that comes from that.
But yes, there can still be a final say in things like schooling, which can be problematic, particularly if they're not dealing with the day-to-day.
And so with co-parents who can't agree and who end up going to final hearing, and effectively the judge makes a decision, does the judge necessarily align with one of the two parents, or can they come up with a completely other arrangement that no one had even thought of?
So they could do that. It would be unusual for them to come up with a brand new arrangement. Okay. But if you're agreed and you file an agreed consent order saying this is what we want the court to do, unless there is something obviously of a welfare issue to what you're proposing, then the court are likely to approve it, particularly if you've had CAFCAS, a safeguarding letter, say that we've spoken to both parents, we've looked at the terms, and these seem to be in the best interests of the child. It's highly unlikely that a judge is going to go against that. But if there are parts that you're not agreed on, remember, with a consent order, you need to agree on everything. So if there are some bits that you're not agreed on, which is often the case for many parents, and you just can't reach an agreement, then it is down to the judge to make a decision on that. And from that, they'll listen to what both parents say. They might listen to what a CAFCAS officer has said as well, any other evidence that they've got before them, and ultimately they can make a decision. And it's also worth noting that if your case doesn't have a particular complexity to it, if it is a matter of how many days or nights are they going to spend with each parent and there are no welfare issues, you're likely to not have a judge listen to it. You're likely to have a board of magistrates listen to it and listen to your application. So it's probably going to be magistrates who would make that decision as well. So it's just worth thinking about that before you do make the decision of lodging that application.
Thanks for clarifying that. So just, I guess, to wrap up, I like to finish with asking my guests for 3 tips. So, if you're somebody who's going through divorce, or even, before or after the actual divorce, but you don't know whether a parenting plan is sufficient or whether you need a formal order, what would be your 3 tips to them to help make that decision?
My first tip would be, every single conversation that you have, think about what is going to work for our children, because I think a lot of parents really struggle because they will think about what friends are doing, think about what other families are doing, maybe think about what the other parent wants and how that's going to work for them, or vice versa. And sometimes in the heat of all of that, you can lose actually what practically is going to work for our children in our circumstances. And sometimes the answer to that is completely different to what your friends might have done for whatever reason. So always think children first. And I find that if you start every conversation with your other half or your ex with that in mind, it can usually start things off on the right foot. If an issue arises where you can't agree on that, I do think it's important to get some legal advice if you are struggling with agreeing the terms, because even if you get half an hour with a solicitor on the phone, lots of solicitors will offer fixed fees or free advice. It will give you so much information that you didn't know was an option to you. And I think it can be invaluable to do that at the outset, particularly if you can't agree on things. Because, as I said at the outset, once things are put in place, it's much harder to go back and say, actually, I didn't want to agree to that, but I did anyway. It's much easier to think of what your strategy is at the beginning of a case to do it then. And then third, think about alternates to court rather than just going straight into the court process. There are so many. The court process is full. There are so many applications that are being made, mainly by litigants in person who don't know where else to turn. And what that means is there are huge, long delays. So it can often not be the solution that everybody expects it to be when there are breakdowns of communication or breakdowns of agreement. So think about the options. There are options of going to mediation, which don't work for everybody, but it can be really, really helpful if you're just reaching a roadblock with your other half and you can't quite agree those final arrangements. Other alternates are arbitrating issues as well, which can also be a much quicker and straightforward way of getting an answer if you and they can't agree on what you want for the children. But I think they would be my top tips.
Those are brilliant. Thank you so much, Rachel.
No, it's a pleasure.